There has been many efforts to ensure the equal employment opportunities in the United States. And today I would like to talk about the two constitutional amendments, the 13th and 14th Amendment. What are the contents of these two amendments and how did they help protect the equal employment opportunities? I would also like to share the case of Regents of University of California versus Bakke in terms of a reverse discrimination. 13th Amendment to the United States Constitution was passed in 1965. It abolished the slavery and involuntary servitude. But we have to note here that we have to examine the situation where the involuntary servitude would serve as the punishment of a crime. So before the 13th Amendment, in the original Constitution, slavery was actually implicitly permitted. Even it was a big victory after the American Civil War, it was really hard to enforce it, especially in some southern states. And you may think that it's not applicable anymore today, since it won't be possible to cite any example of race-based slavery. Rather, we should interpret it in a more evolutionary manner. Besides, the article allows the Congress to pass laws pertaining to practices that violate the amendment. For instance, the passage of the Anti-Peonage Act. It's also been applied in cases where discrimination involved the badges and incidents of slavery. So an example would be the court held that racial discrimination by private housing developers and private schools is among the badges and the incidents of slavery. 14th Amendment forbids the states from taking life, liberty, or property without due process of law and prevents the states from denying the equal protection of the law. It has been applied to the protection of the whites from reverse discrimination as well. So now I would like to share the case of Regents of University of California versus Bakke. So Alan Bakke alleges that he had been discriminated against in the selection of entrance to the University of California at Davis Medical School as white. The university had the quota system where among every 100 positions, 84 are for white candidates that Alan Bakke can compete for. While the minority applicants, they were actually able to compete for all the 100 positions. So in this case, the federal court ruled in favor of Bakke, noting that the quota system had violated white individuals' rights to equal protection under the law. And note that the 14th Amendment only applied to the decision or the actions of the government or the private groups whose activities are deemed government actions. So therefore, if you want to file a claim under 14th Amendment, if you are fired from a state university, a type of a government organization, then you can do that. But you can't do it if you're fired by a private employer. Both the 13th and 14th Amendment contribute to the equal rights and protections in the United States, but through a series of fights. After the 13th Amendment, southern states had begun to institute black codes, trying to keep Black Americans in the position of inferiority. And historians had different arguments about the initial intent of the 14th Amendment. And multiple states actually rejected the 14th Amendment, or some of them resented acceptance. But the fight for the equal rights have never stopped in the United States.